pursuant to several international conventions. Nakada's case similarly underscores various public health risks of cannabis, including dependency, cognitive impairment, and mental health disorders, as documented in its national surveys. Nakada argues that the limitation of the petitioner's rights is reasonable, justifiable under Article 24 of the Constitution. So I'll now skip to the conclusion. It explains the determination as well. Just a moment. As I conclude, while the amended petition herein was not on the question of a whole-scale decriminalization of cannabis use in Kenya, a few thoughts on the topic within this judgment would be apt. It is beyond dispute that use of cannabis in this country has become ubiquitous and has arguably been so for many decades. Indeed, the petitioners showed that products that contain cannabinoids are being freely sold in mainstream shops and supermarkets. So-called weed cookies are openly marketed, sold, and consumed in our country. Many prominent Kenyan personalities have even admitted to past or present cannabis use, and being associated with it no longer has the shock effect it had in former times. Internationally, Peter Tosh's seminal 1976 ode to the decriminalization campaign, the song Legalize It, has two stanzas that speak clearly on where many modern societies have reached vis-a-vis cannabis. So those two stanzas read, singers smoke it and players of instruments too. Legalize it, yeah, yeah, that's the best thing you can do. Doctors smoke it, nurses smoke it, judges smoke it, even lawyers do. As I stated at the beginning of this judgment, we are awash with cultural expressions touching on cannabis use. Beyond music, many of our public service vehicles, and in particular Nganyas, exhibit imagery or text associated with cannabis or cannabis use. It is not a question for the Rastafarian community only. It is a national question that cuts across the entire spectrum of our society. Just a moment, let me mute that person. It is not a question for the Rastafarian community only. It is a national question that cuts across the entire spectrum of our society. This is not to excuse cannabis use or to argue that it should be legalized merely because the war is lost, as it were. Rather, it is to ask whether we need to have a national social conversation outside of courts and legislative houses on what do we now do with this phenomenon in light of what it has become in our society. That conversation could, perhaps, even extend to whether the expenditure of our nation's very scarce law enforcement and prosecutorial resources on small amounts, possession, or personal use is appropriate, given that those resources are the same ones we deploy to address sexual offenses, robberies with violence, assaults, and other grave offenses. Ultimately, our nation can no longer address the issue as the proverbial ostrich does, by burying our collective heads in the sand. We ought to have a full and frank conversation on cannabis and which direction we should take. The status quo appears untenable. Returning now to the four corners of the matter that was squarely before the court, it is the conclusion of this court that, for the reasons set out above, the petitioners have not discharged the burden of proving that the impugned provisions of the Narcotic Drugs and Psychotropic Substances Control Act violate their constitutional rights. The petitioners have also not exhausted the available legal and administrative mechanisms before invoking the constitutional jurisdiction of this court. The evidence on the centrality of cannabis to the Rastafari faith was also inconsistent and does not demonstrate that its use is an essential element of the religion. The limitation of the petitioner's rights, if any, is reasonable and justifiable under Article 24 of the Constitution, as the impugned provisions serve the legitimate and pressing purpose of ostensibly protecting public health and safety. Accordingly, I make the following final orders. A, The amended petition dated 24th May 2021 is hereby dismissed in its entirety. And B, each party shall bear their own costs. Orders accordingly, file closed accordingly. Dated, signed, and delivered virtually this 15th day of July 2026.
Much obliged, my lord.
Judge, we thank you, and on behalf of the society and the country at large, thank you for the judgment.
So as I said earlier, just after I finish with the other judgments for Milmani, I'll take a 5-minute break and then I'll upload it onto CTS. So you should have it within the next few minutes.
Fair enough, my lord.
So thank you.
My lord, we look forward to receiving it so that we can be guided by our clients on the next appropriate step to take.
Yes, you'll have it by 10:15. You'll have it. I don't think I have too many more Milimani matters. I think I have only 3 more. So thank you, Council. Have a good day.
A good day to you too, my lord. Thank you.
My lord, perhaps just before you call out the next matter.
Yes.
Apologies for interrupting.